Grabe, ang hirap mag-aral. I totally get it. So, as I said sa previous video, I would be skipping 115. Guess it's just one section. So, we will be discussing 116. So, study with me, Sesh, ulit, and I'll be reading Codal and then discussing the concepts and then bar cues. So, Rule 116, Arraignment and Plea. Section 1, Arraignment and Plea how made. The accused must be arraigned before the court where the complaint or information was filed or assigned for trial. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not guilty. The prosecution may call at the trial witness other than those named in the complaint or information. The accused must be present at the arraignment and must personally enter his plea. Both arraignment and plea shall be made of record, but failure to do so shall not affect the validity of the proceedings. When the accused refuses to plead or makes a conditional plea, a plea of not guilty shall be entered for him. When the accused pleads guilty but presents exculpatory evidence, his plea shall be deemed withdrawn, and a plea of not guilty shall be entered for him. When the accused is under preventive detention, his case shall be raffled and its records transmitted to the judge to whom the case was raffled within 3 days from the filing of the information or complaint. The accused shall be arraigned within 10 days from the date of the raffle. The pre-trial conference of his case shall be held within 10 days after arraignment. The private offended party shall be required to appear at the arraignment for purposes of plea bargaining, determination of civil liability, and other matters requiring his presence. In case of failure of the offended party to appear despite due notice, the court may allow the accused to enter a plea of guilty to a lesser offense which is necessarily included in the offense charged with conformity of the trial prosecutor alone. Unless a shorter period is provided by special law or Supreme Court circular, the arraignment shall be held within 30 days from the date the court acquires jurisdiction over the person of the accused. The time of the pendency of a motion to quash or for bill of particulars or other causes justifying suspension of the arraignment shall be excluded in computing the period. Section 2. Plea of guilty to a lesser offense. At arraignment, the accused, with the consent of the offended party and the prosecutor, may be allowed by the trial court to plead guilty to a lesser offense, which is necessarily included in the offense charged. After arraignment but before trial, the accused may still be allowed to plead guilty to said lesser offense after withdrawing his plea of not guilty. No amendment of complaint or information is necessary. Section 3. Plea of guilty to capital offense, reception of evidence. When the accused pleads guilty to a capital offense, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea, and shall require the prosecution to prove his guilt and the precise degree of culpability. The accused may present evidence in his behalf. Section 4. Plea of guilty to non-capital offense, reception of evidence, discretionary. When the accused pleads guilty to a non-capital offense, the court may receive evidence from the parties to determine the penalty to be imposed. Section 5. Withdrawal of improvident plea of guilty. At any time before the judgment of conviction becomes final, the court may permit an improvident plea of guilty to be withdrawn and be substituted by a plea of not guilty. Section 6. Duty of court to inform accused of his right to counsel. Before arraignment, the court shall inform the accused of his right to counsel and ask if he desires to have one. Unless the accused is allowed to defend himself in person or has employed counsel of his choice, the court must assign a counsel de officio to defend him. Section 7. Appointment of counsel de officio. The court, considering the gravity of the offense and the difficulty of the questions that may arise, shall appoint as counsel de officio such members of the bar in good standing who, by reason of their experience and ability, can competently defend the accused. But in localities where such members of the bar are not available, the court may appoint any person resident of the province and of good repute for probity and ability to defend the accused. Section 8. Time for counsel de officio to prepare for arraignment. Whenever a counsel de officio is appointed by the court to defend the accused at the arraignment, he shall be given a reasonable time to consult with the accused as to his plea before proceeding with the arraignment. Section 9. Bill of Particulars. The accused may, before arraignment, move for a bill of particulars to enable him properly to plead and prepare for trial. The motion shall specify the alleged defects of the complaint or information and the details desired. Section 10. Production or inspection of material evidence in possession of prosecution. Upon motion of the accused, showing good cause and with notice to the parties, the court, in order to prevent surprise, suppression, or alteration, may order the prosecution to produce and permit the inspection and copying of or photographing of any written statement given by the complainant and other witnesses in any investigation of the offense conducted by the prosecution or other investigating officers, as well as any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things not otherwise privileged, which constitute or contain evidence material to any matter involved in the case and which are in the possession or under the control of the prosecution, police, or other law investigating agencies. Section 11. Suspension of arraignment. Upon motion by the proper party, the arraignment shall be suspended in the following cases. The accused appears to be suffering from an unsound mental condition which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. In such case, the court shall order his mental examination and, if necessary, his confinement for such purpose. There exists a prejudicial question and a petition for review of the resolution of the prosecutor as pending at either the Department of Justice or the Office of the President, provided that the period of suspension shall not exceed 60 days, counted from the filing of the petition with the reviewing office. So that's it for the CODAL, and then I'll take a short break and then we will go straight into the discussion. So sa Bar Syllabus, wala namang sinabi. Just said rights of the, arraignment and plea. Okay, so what is arraignment? Iba yung arraignment sa plea. Arraignment, this is when the accused is informed of the accusation against him, yung reason for his indictment, kung ano yung charges, kung ano yung mangyayari, kung ano yung consequences, kung basically ni-inform siya. Ni-inform siya ng kaso against him, pati yung evidence against him, and yung possible penalty against him. Yung plea naman, ito yung knowing fully well kung ano na yung kinakaharap niyang kaso. He is given the chance to plead guilty or not guilty, and that will set the course of trial. So, importante in making a plea that the accused knows fully well yung plea niya. Kung guilty ba siya or not guilty, informed siya, and naiintindihan niya yung consequences of making such plea. So what is a searching inquiry? It means informing cursorily the accused that he faces imprisonment. So guidelines for conducting a search inquiry: ascertain from the accused himself how he was brought into custody of the law. Alam mo ba kung bakit ka nandito? Did you have assistance from a competent lawyer or counsel? Was there custodial and preliminary investigation? Ano yung conditions na nung time na yon when you were detained, when you were interrogated? Then the defense counsel asks a series of questions whether everything was explained to him, the meaning and consequences of making a plea, so guilty or not guilty. Elicit also information about the accused, and then inform the accused that most likely, if matalo, this would be the penalty, the length of time of imprisonment, the nature of the penalty, and inquire if the accused knows the crime, kung alam niya kung ano yung charge against him. Basically, just, ensuring that the accused understands, comprehends what his situation is at the moment, and how his situation will be in the course of trial, and all the possibilities. So the trial judge must satisfy himself that the accused in pleading guilty is truly guilty. So the accused must be required to narrate the tragedy or reenact the crime or furnish its missing details. What is an improvident plea? An improvident plea is one without proper information as to all circumstances affecting it, based upon a mistaken assumption or misleading information or advice. So this is a no-no. So what is the effect of an improvident plea? As a general rule, plea of guilty should not be accepted if it's an improvident plea, kasi hindi nga alam, nag-plead lang ng guilty na hindi niya man naintindihan, or hindi naman talaga yun yung gusto niyang plea. So it should not be accepted and should not be held to be sufficient to sustain a conviction. If the accused does not clearly or fully understand the nature of the offense charged, that's an improvident plea. If he is not advised as to the meaning and effect of the complaint against him, or the information, as the case may be, or the qualifying acts, if it does not clearly understand the consequences of entering into a plea of guilty. The exception is if the accused appears guilty beyond reasonable doubt from the evidence adduced by the prosecution and defense. So, kahit na may mga ganyang factors pero hindi niya naiintindihan, pero based on evidence, talagang parang guilty siya, evidence of guilt is strong, then it may still be accepted. So when improvident plea may be withdrawn at any time before judgment of conviction becomes final. The court may permit an improvident plea of guilty to be withdrawn and to be substituted by a plea of not guilty. The withdrawal of plea of guilty is not a matter of right of the accused, but of the sound discretion of the trial court. And the reason for this is that trial has already begun, and the withdrawal of plea will change the theory of the case and put all past proceedings to waste. So, yan lang naman yung importante sa arraignment and plea. Basically, just the plea. Ano pa yung pwede nating pag-usapan tungkol sa arraignment and plea? Let's see. Pinipili ko na lang kasi plea when and how made in an open court where the complaint or information has been filed or assigned for trial, and by the judge or clerk of court by furnishing the accused with a copy of the complaint or information. Dapat meron siyang copy. Reading it in a language or dialect known to the accused, kasi importante na iintindihan niya. By asking the accused whether he pleads guilty or not guilty, and the accused must personally appear during arraignment and enter his plea. Both arraignment and plea shall be made of record, but failure to enter of record shall not affect the validity of proceedings. So, kailangan personal appearance talaga para ma-ascertain ng court na naiintindihan niya yung plea niya. So, that means that the lawyer of the accused or the counsel of the accused cannot enter the plea on his behalf. Bawal yun. And mere written motion or manifestation is not even a valid plea. Dapat personally made sa court by the accused himself. So, arraignment and pretrial shall be set within 10 calendar days from the date of the court's receipt of the case for detained accused and within 30 calendar days from the date the court acquires jurisdiction. Pero pwede siyang shorter period if the complainant is about to depart from the Philippines tapos parang hindi alam kung kailan babalik. So dapat agad-agad i-arraign na yun. Or Child Abuse Act, dapat within 3 days, nasa special penal laws yan. Dangerous Drugs Act, yun. CICL, within 7 days from date of filing. Pwede ba mag-arraignment during trial? Parang hindi. Dapat arraign muna bago mag-trial. Kasi yung arraignment, yun yung magsaset ng course ng ano eh. Pero, pwede naman if the counsel of the accused failed to object lack of arraignment during trial. Counsel of the accused had full opportunity to cross-examine the witnesses. But, this is a bad practice. So, what is the effect of absence or irregularity of arraignment? It results in the nullity of the proceedings. Judgment is void if accused has not been validly arraigned. Improvident plea of guilt nga, diba? Hindi pwede. Ano mo yun, hindi mo yun i-consider. But that will not affect the proceedings. Pero it's very important na may arraignment. Belated arraignment, which is done only after the case has been submitted for decision, does not necessarily violate the constitutional right of the accused, because the subsequent arraignment will cure the error, provided that the accused was able to present evidence and cross-examine the witnesses of the prosecution during trial. Arraignment must be made again in an amended information or complaint, only where substantial amendments are made and not mere formal amendments. Accused is presumed to have been validly arraigned in the absence of proof to the contrary, except when the offense charged is punishable by death. Accused must personally appear. So yun. Trial in absentia may be conducted only after valid arraignment. Without valid prior arraignment, the accused cannot invoke double jeopardy. Wala pa eh. So ano yung conditional plea of guilty? Plea entered by the accused subject to the proviso that a certain penalty be imposed upon him. So it's equivalent to a plea of not guilty. So is a plea of guilty a judicial confession? Yes. As a general rule, it is elementary that a plea of guilt is a judicial confession of guilt, an admission. Kaya nga pinapa-reenactment, pinapa-narrate, yan. So, pag-usapan siguro natin plea bargaining. Plea bargaining in criminal cases is a process whereby the accused and the prosecution work out a mutually satisfactory disposition of the case subject to court approval. It usually involves the defendants pleading guilty to a lesser offense or to only one or some of the counts of a multiple count indictment in return for a lighter sentence than that for a graver charge. The acceptance of an offer to plead guilty to a lesser offense is not demandable by the accused as a matter of right, but is a matter addressed to the sound discretion of the trial court. So, kailangan ng consent of the offended party, of course. The prosecutor, kasi siya mag-enter into negotiation with the other party. And the plea to a lesser offense, which is necessarily included in the offense charge, so caudal, and approval of the court must be obtained. So, kailan required yung offended party to appear in arraignment? Well, kailangan nandun siya sa arraignment for purposes of plea bargaining or determination of civil liability and other matters requiring his presence. Para siyang witness eh. Pero, kung wala namang plea bargaining, kung ayaw naman niya mag-pursue ng civil liability or nag-institute ng separate civil action, pwedeng wala siya doon. And in case of failure of the offended party to appear, despite due notice, the court may allow the accused to enter a plea of guilty to a lesser offense, which is necessarily included in the offense charged with conformity of the trial prosecutor alone. Kasi normally, di ba, kailangan ng consent niya. So, plea bargaining kailan? Sa arraignment mismo pwede. Or before arraignment and pre-trial. So, except in drug cases, if the accused desires to enter a plea of guilty to a lesser offense, plea bargaining shall immediately proceed, provided the private offended party in private crimes or the arresting officer in victimless crimes is present to give his or her consent with conformity of the public prosecutor to the plea bargaining. Ano yung private crimes ulit? Yun yung adultery, concubinage, acts of lasciviousness, abduction, seduction, defamation. Thereafter, judgment shall be immediately rendered in the same proceedings. If no plea bargaining takes place after arraignment or before the trial, the accused may still be allowed to plead guilty to a lesser offense. But that is after withdrawing his plea of not guilty. Kasi magpiplead siya na guilty but for a lesser offense. In this plea of guilty to a lesser offense, no amendment of the complaint or information is necessary. That's Kodal. Nabasa ko na yan kanina. So, pag the accused pleads guilty to a capital offense, yun ka magsa-searching inquiry. Yun yung sinabi ko kanina, no? Yung inquire mo talaga kung naiintindihan niya. And the reception of evidence here is mandatory. However, defendant after pleading guilty may not present evidences would exonerate him completely from criminal liability such as proof of self-defense kasi nag-plead ka na guilty. Bawal na yun. Dapat nga may consent ng court kasi mag-change yung course ng trial. Lahat ng proceedings parang binasura. Okay. So, in counsel de officio, counsel appointed by court to represent and defend the accused if he cannot afford to employ one himself or walang mahanap. So, anyone could be appointed as counsel de officio, such members of bar in good standing. Kung walang members of bar, walang lawyer, then any resident or of the province of good repute, probity, and ability. Dapat naman competent. So, koda lang din yan. Bill of Particulars. The accused may before arraignment move for Bill of Particulars to enable him to plead and prepare for trial. So, yung Bill of Particulars, this is kapag vague yung allegations ng complaint or information, pwede siyang mag-ask ng more para mas maintindihan niya and makaprepare siya ng defense and can properly plead. So, if hindi siya nag-ask ng Bill of Particulars at that point, that's a waiver of his right. Ibig sabihin clear sa kanya and okay na siya doon. So, the motion of Bill of Particulars shall specify the alleged defects in the complaint and information and details desired by the accused. Kung ano pang gusto niyang malaman na parang feeling niya kulang or di niya maintindihan doon. So, however, the Bill of Particulars should not be used to supply material allegation necessary to the validity of pleading or change the cause of action or defense stated in the pleading or set forth the pleader's theory of his cause of action or a rule of evidence on which he intends to rely, or furnish evidentiary information, whether such information consists of evidence which the pleader proposes to introduce or of facts which constitute a defense or offset for the other party or which will enable the opposite party to establish an affirmative defense not yet pleaded. So, upon motion of the accused, showing good cause and with notice to the parties, bawal kasi surprise dapat fair game. Dapat alam ng accused yung mga nilalaban against him para can make proper defense. Hindi pwede yung sa trial mo na lang i-release. Dapat lahat ilatag mo na yan sa arraignment. Walang gulatan. Right of the accused to move for the production of material evidence in the possession of the prosecution. That's also okay. It authorizes the defense to inspect, copy, or photograph any evidence of the prosecution in its possession after obtaining permission of the court. So, suspension of arraignment, kapag accused appears to be suffering from an unsound mental condition that renders him unable to fully understand the charge against him and to plead intelligently. Or if there's a prejudicial question, which we already discussed, it has to be resolved first. Or petition for review of the resolution of the prosecution is pending sa DOJ or Office of the President. So, question pa yung determination ng prosecution to pursue the case. So, suspend muna. Kasi baka kapag may prejudicial question, syempre suspend naman talaga yung criminal proceedings muna. Or kapag may appeal ka din sa DOJ or Office of the President, so, or regional prosecutor, state prosecutor, di ba yung bagong law? So, pwedeng hindi matuloy yung kaso, di ba? So, that's it. And, bar questions naman na tayo. Okay, so bar cues. Mr. W was charged with raping his neighbor, 17-year-old daughter, AA. When he was arraigned, Mr. W expressed his desire to plead guilty, provided that his sentence be substantially reduced. Both AA's mother and prosecutor are amenable. Okay lang, consent ng prosecutor at defendant party. Dapat may consent din ng court. Consequently, the judge entered the plea of guilty for Mr. W and sentenced him to serve. Judge nag-enter ng plea of guilt. Did the judge properly enter a plea of guilty? Conditional plea ito eh. Diba ba sinabi natin kanina, pag conditional plea, not guilty. So the answer is no, the act of Mr. W is a conditional plea, meaning subject to condition that he be punished. Certain, in that case, trial court should have vacated such plea and entered the plea of not guilty for a conditional plea of guilt. Or one with a proviso that a certain penalty be imposed upon him. A conditional plea of guilty is equivalent to a plea of not guilty. Therefore, would require full-blown trial. May alternative answer dito. Rape is considered a capital offense. Punishable by reclusion perpetua. Yep. Duty bound to conduct a searching inquiry to voluntariness. Actually, nakalimutan natin yung searching inquiry. Dapat may searching inquiry muna. Full comprehension of the consequences of plea of guilt. Yep. Assuming that Mr. W was once more charged with crime of rape against AA based on same incident. Pwede kung separate count, separate instance. Mr. W validly invoked the defense of double jeopardy through motion to quash? No. Basta separate incident eh. So answer is no. Which is Mr. Which was based on is also void. Appellation cannot consider of attained finality. For simple reason that the void judgment has no legality from its. Di ko na alam kung bakit naging void yung judgment. Kasi nga mali yung pag-enter ng plea of guilt. So, ano to? Sub-question. Okay. D was charged with theft of an article worth 15,000. Upon being arraigned, he pleaded not guilty to the offense charged. Thereafter, before trial commenced, he asked the court to allow him to change his plea of not guilty to a plea of guilty, but only to a staff up if the court allowed D to change his plea. Hindi. Theft eh. But estafa, dapat yung plea mo necessarily included doon. Layo naman. Swindling yung estafa, theft yung ano. No. So the answer is no, because the plea of guilty may be allowed if the lesser offense is necessarily included. Estafa involving 5,000 is not necessarily included in the theft of article worth 15,000. Yeah. So apparently yun lang yung bar cues dito na meron. Okay, so yun lang. Yung next natin is grabe, nakakapagod mag-aral. 117, motion to quash. Information, grounds, double jeopardy, provisional dismissal. Yung tatlong yun. Konti na lang. Tapos pre-trial, judgment, new trial, appeal, provisional remedies. Yay! Okay. Okay, so bye and God bless.